Let's take you now to that news conference in Cuyahoga County, where the Cuyahoga County Prosecutor, Tim McGinty, is going to be talking to reporters. Let's listen in.
Am I okay with everybody's microphone there?
Yes.
Okay. Man. Good afternoon, ladies and gentlemen. My name is Tim McGinty, the Cuyahoga County Prosecutor. 4 years ago, I retired to run for county prosecutor to make our criminal justice system more transparent, professional, and accountable. I believe that greater openness would reduce the errors that cost lives. One promise I made was to fundamentally change how cases are handled when a police officer kills a civilian, to end the traditional system where the prosecutor privately reviewed police reports, then decided if an officer should be charged. That secrecy, which appeared arbitrary without a public investigative report, undermined community confidence. It was clear we needed a more rigorous, independent investigation of police use of deadly force cases. Although not required by Ohio law, I now have all evidence reviewed not just by the prosecutor in these cases or this office, but by the citizens of the grand jury sitting as an investigative panel. They hear all the evidence and make the final call. Our office also shares with the public completed independent investigative reports so that there will be no mystery about what occurred or rumors in a citizen's death. This transparency gives our community an opportunity to correct errors in policy, training, tactics, hiring, equipment far more quickly instead of waiting sometimes years until the opportunity and enthusiasm for reform are lost. The lessons are forgotten. Here, we want the lessons learned and applied. That is why what we have done and we will do in all 20 use of force cases that have come to this office in the past 3 years. Today, a Cuyahoga County grand jury completed its thorough investigation of the fatal shooting of the 12-year-old Tamir Rice on December 22, 2014 at the Codell Recreation Center. Based on the evidence they heard and the law as it applies to police use of deadly force, the grand jury declined to bring criminal charges against Cleveland police officers Timothy Lohman and Frank Garmbeck. That was also my recommendation and that of our office after reviewing the investigation and the law. A short time ago, we informed Tamir's mother of the grand jury's decision. It was a tough conversation. We again expressed the condolences of our office, the sheriff's detectives, and everyone else who has worked so diligently on this case, and our sincere wish that these events on that traumatic day at the Codell Rec Center had unfolded differently. She was broken up, and it's very hard. We explained to her that this was a difficult decision also, but that to charge police, even a situation what was as undeniably tragic as the death of her son, the state must be able to show that the officers acted outside the constitutional boundaries set forth by the Supreme Court of these United States. Simply put, given this perfect storm of human error, mistakes, and miscommunications by all involved that day, the evidence did not indicate criminal conduct by police. On close examination, especially of what is perhaps the most critical piece of evidence, a very recent enhancement of the surveillance video by an expert laboratory often relied upon by the FBI, it is now indisputable that Tamir was drawing his gun from his waist as the police slid toward him and Officer Lohman exited the car. At the point where they suddenly came together, both Tamir and the rookie officer were no doubt frightened. If we put ourselves in the victim's shoes, as prosecutors and detectives try to do, it is likely that Tamir, whose size made him look much older and who had been warned that his pellet gun might get him into trouble that day, either intended to hand it over to the officers or show them it wasn't a real gun. But there was no way for the officers to know that because they saw the events rapidly unfolding in front of them from a very different perspective. Just minutes before, they had been assigned in order to respond to a Code 1 report of a, quote, guy, end quote, pointing a gun at people outside the rec center. That guy, they had been told, was dressed exactly as Tamir was. As they raced that mile towards the rec center from their other assignment, the police were prepared to face a possible active shooter in a neighborhood with a history of violence. There are, in fact, memorials to 2 slain Cleveland police officers in that very park, a short distance away, and both had been shot to death nearby in the line of duty. Police are trained that it only takes a third of a second or less to draw and fire a weapon upon them, and therefore they must react quickly to any threat. Officer Lohman had just seen Tamir put an object into his waist as they pulled up, and he stood up in a gazebo and started walking away. A moment later, as a car slid toward him, Tamir drew the replica gun from his waist, and the officer fired. You'll be able to see an actual Colt 1911 model pistol and a identical replica gun that was used that day. They are very difficult to tell apart, even by people who are very familiar with guns, even when you stand and stare at it. A moment later, as a car slid toward him, Tamir drew the replica gun from his waist and the officer fired. Believing he was about to be shot was a mistaken, yet reasonable belief, given the high-stress circumstances and his police training. He had reason to fear for his life. It would be unresponsible and unreasonable if the law required a police officer to wait and see if the gun was real. The outcome will not cheer anyone, nor should it. Every time I think about this case, I cannot help but feel that the victim could have been my own son or grandson. Everyone here who has worked and investigated this case feels the same way. It brings it all to sadness. Everyone who investigated this case has children who goes to parks and rec centers. No parent follows their 12-year-old around all day to make sure they don't get into mischief. That is why this case taps such profound emotions in all of us. The Rice family has suffered a grievous loss. Nothing will replace Tamir in their lives. The police officers and the police department must live with the awful knowledge that their mistakes, however unintentional, led to the death of a 12-year-old boy. So will the police radio personnel, whose errors were substantial contributing factors to the tragic outcome. They passed along detailed information about the guy outside the rec center, his clothing, including the colors of his coat and his camouflage hat, but not the all-important facts that the 9/11 caller said the gunman was probably, quote, probably a juvenile, and the gun may not be real. Had the officers been aware of these qualifiers, the training officer who was driving might have approached the scene with less urgency. Lives may not have been put at stake. The fact that the Code 1 high-priority call about a possible active shooter next to a rec center was based on inaccurate information is a very significant legal fact, but will do little to ease the emotional burdens that the family and all involved must now carry. Our entire community has suffered through gut-wrenching self-examinations and recriminations. When an innocent civilian, let alone a child, is killed by a police officer, it touches the nerves that lie close to the surface of all of us in society. That is especially true since the events in places such as Ferguson and Chicago have exposed a gulf of distrust and resentment that too often divides police from the very communities they serve. And when the public is kept in the dark about facts of an investigation into these incidents, that distrust can grow. All those emotions are compounded when a 12-year-old boy is killed on video. But the original grainy video that had been shown repeatedly on TV is only a small part of the story here, a very important but small. That is why this case demanded a professional and dispassionate investigation to determine if this was indeed a tragic crime or a tragic accident. The Supreme Court instructs us to judge an officer's conduct by what he or she knew at the moment, not by what was learned later. We are instructed to ask what a reasonable police officer with the knowledge he had would do in this particular situation. The Supreme Court prohibits second-guessing police tactics with 20/20 hindsight. And the law gives the benefit of the doubt to the officers who must make split-second decisions when they reasonably believe their lives or those of innocent bystanders are in danger. Based on these rules, it became clear through this investigation that the actions of officers Lohman and Garbeck were not criminal. And the reasons for this, Assistant County Prosecutor Matthew Meyer and James Gutierrez have outlined in a written report that will be available online when you leave here. In a few moments, I'm going to ask Assistant Prosecutor Meyer to provide a detailed factual and legal analysis of this case, the improved evidence that we have discussed already. But now, let's deal with it. The death of Tamir Rice was an absolute tragedy. It was horrible, unfortunate, and regrettable, but it was not, by the law that binds us, a crime. Through this process, we too have heard the chants, and we too want justice for Tamir. But justice would not be achieved by bringing charges that would violate the ethical canons of our profession, because we know these charges could not be sustained under the law in our Constitution. This decision does not mean the legal system is finished with this case. In our country, we have parallel systems of justice, and the civil justice system may yet provide the Rice family with some of the accountability they deserve. But the grand jury lived with this case for more than 2 months, heard all the witnesses, and was there to evaluate each witness's credibility and to question them. In cases where the police used deadly force against the citizens, we now have other citizens review the evidence and make the final call. As a local judge recently said, if you don't trust the grand jury, you don't trust your neighbors. I trust the people of Cuyahoga County to make the final call, and that's why I've changed this procedure, in this case and every other case of police use of deadly force in this county. Now, there have been lessons learned already in this case. That is the plus side of this tragic event. And it should never happen again. And steps have been taken to see it does not. First, the city has bought body cams for all its officers, and that should help greatly. They will know exactly what happened in these situations. Dash cams are on the way for Cleveland Police Department and the suburban departments, in part using the $1 million this office provided from seized and forfeited monies from criminals and criminal convictions. Our goal is to have every car, every police car in Cuyahoga County, including Cleveland and all the suburbs, with dash cams and officers all wearing body cams. It will improve public confidence and improve performance and protects both the officer and the individual. We'll know exactly what happened in the future. And public confidence rises and complaints fall dramatically. It has been shown across the country. The second important event that has taken place since this occurred is a consent agreement between the city and the City of Cleveland and the Department of Justice. That will dramatically change the way the city hires, trains, and manages its police. I once again applaud Mayor Jackson and Council for their leadership on this issue, and Police Chief Williams, who is determined to constantly improve the department, and he has. They have a great chief and a great mayor. And finally, I want to call on the legislature and the manufacturers of toy guns not to make guns that look so much like the real thing. If the color and design of Tamir's pellet gun had screamed toy, then the call that set this tragedy into motion may never have happened. The grand jury has fully investigated this case and made its final decision. Now it is time for the community and all of us to start to heal. We have taken steps to learn. We're going to continue to learn. We're going to continue to improve the quality of the justice system we have here in this county. But before anyone reaches their own conclusions, and everyone's welcome to their own, we ask please to review the facts and evidence this investigation has uncovered. We have issued the report of the Sheriff's Department, and I thank Sheriff Pinckney and Detective Morgan and all the other detectives who worked on this case here, and all the hard work they put in. Look at the report, look at the facts, look at the law. That's why we put the reports out as they come in. So We're not making decisions based on rumors or hearsay or the like. These are actual facts, and we can learn from these facts. I call for the leaders of our community to now respect the process and the decision of the grand jury and to urge others to express their opinions in a peaceful and lawful manner. I appreciate the sincere emotion and concern of all citizens who have expressed their feelings on this case, and we thank them. We thank them for caring, and I will now turn this over to Assistant Prosecutor Matt Meyer, who's the head of the Public Corruption Unit of our Cuyahoga County Prosecutor's Office. He's a former chief of the Appellate Unit. And Mr. Meyer argued successfully at the United States Supreme Court this spring, and an opinion issued 9-0 this fall in what I consider a landmark case, Ohio versus Clark. I thank him. I thank Jim Gutierrez and all the other prosecutors here who have worked on this case and the other UDFs, use of deadly force cases. We've had many. Just earlier this month, we had 2 police officers within a 3-day period shot in the chest by assailants. Both individuals were killed by other police officers, not the person shot. But this is a violent society with all these guns. This is a tough job, and to investigate these cases, and I thank the individuals who actually do the work. And now we'll hear from Mr. Myers. Thank you very much for your attention.
I'm going to have to put this somewhere else.
The balance up here.
All right, thank you. Prosecutor McGinney touched on the legal standard, but it is necessary to frame the discussion with a full understanding of the unique set of laws that apply when anyone reviews a police use of deadly force incident. In a case called Graham versus Connor, the United States Supreme Court said that in any review of a police officer's use of deadly force, the court requires that the incident be analyzed under the Fourth Amendment and its reasonableness standard. Without the Fourth Amendment analysis, it is not possible to determine whether an officer's use of deadly force is or is not a crime. In a case called Tennessee versus Garner, the United States Supreme Court again said that a police officer may use deadly force when the officer has probable cause to believe that the suspect poses a threat of serious physical harm to the officer or to others. In the Graham case, the U.S. Supreme Court again said that the reasonableness of the officer's actions must be judged from the perspective of the reasonable officer on the scene and not through the lens of 20/20 hindsight, allowing for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. In a recent United States Court of Appeals case for the Sixth Circuit called Mullins versus Cyranak, decided this past November, the court said that in making this judgment, we must be careful not to substitute our personal notions of proper police procedure for the instantaneous decision of the officer on the scene. Rather, we must adopt a built-in measure of deference to the officer's on-the-spot judgment about the level of force necessary in light of the circumstances of a particular case. After all, what constitutes reasonable action may seem quite different to someone facing a possible assailant than to someone analyzing the question at leisure. In a case called Livermore versus Lublin, the Sixth Circuit Court of Appeals again explained that when reviewing an officer's use of deadly force, we must disregard the events leading up to the incident of deadly force and instead focus on the split-second judgments made immediately before the officer allegedly used excessive force. Turning to the facts
All right,
of this
we've been
case,
listening in there to officials at the Cuyahoga County Prosecutor's Office. Heard a short time ago from the county prosecutor himself, Tim McGinty, who went through some of the background before he actually talked about what the grand jury's decision was, a decision not to return any charges against the two officers who were involved, who were there rather, during the shooting death of Tamir Rice. We heard the prosecutor say, given this perfect storm of human error, the evidence did not reveal criminal conduct by police. Let's bring in our Jamie Yukas, CBS News correspondent, who has been covering this story. And Jamie, I think a lot of people just need to be reminded about the basic outlines of this case, because this is a case that happened in more than 400 days since the death of Tamir Rice, 12 years old. It was November 22nd, 2014. When a call came in to 911 dispatchers about someone in the park with a gun. Remind us of what transpired.
Well, and what's interesting about that, Elaine, is that is almost the first outline of human error in this case, because the 911 caller did say that he believed that the assailant, rather the suspect, Tamir Rice, was a juvenile. Also said that they believed that the gun could be fake, but they weren't sure. But that was never relayed to the officers in this case. So the officers came up into an area of West Cleveland, which is known to be a little bit rougher in some parts of that town, came up on the recreation center where Tamir Rice was. And as you can see in the surveillance video that's been widely circulated both on the internet and through news reports, you can see Tamir Rice at the recreation center. The police cruiser speed up. You then see that rookie officer, Mr. Lohman, get out of the vehicle and almost immediately shoot Tamir Rice. Now, I think this is really where the questions started being raised by both the family of Tamir Rice and the officers. The officers' point of view, as Mr. McGinty said in the press conference a few moments ago, is that the officers feared for their life. They believed that Tamir was going into his waistband and about to pull out what they believed was a real gun, turned out to be a replica. The family, though, I've talked to the family's attorney several times, and they say that if you take a look at this video, to them and their experts, which they ended up submitting to the grand jury as well, that their experts believe that Tamir may have been shot so quickly that it was his reaction to being shot is when his arms go up, and possibly the reaction from the bullets hitting him, that the sweatshirt kind of lifts up in a manner. So I think that's really the difference of opinion between the officers saying that they were fearful, they thought he was reaching for a gun that they believed to be real, and the family saying, no, wait a minute, this happened so quickly that this is the reaction to him being shot. His shoulder goes up, his hand goes back, and his sweatshirt reveals part of his stomach.
And there we see, this is the thing that the prosecutor was pointing out, how similar the replica looked to an actual handgun, a Colt-type handgun. But this was a pellet gun that, as we understand it, Jamie, correct me if I'm wrong, the orange tip, which is sort of the marker that this is not a real gun, had been removed from the gun that Tamir Rice was holding.
It had, and I would think that's probably another indication that the county prosecutor was talking about in terms of human error. Tamir and his friends had been playing with this gun. Apparently the orange tip had been removed, so that came into question then immediately. Is this a real gun or is it not? Now, some people at the park, when they did call 911, said it may be a pellet gun or an airsoft gun, a fake gun. But as you can see from these pictures, they do look very similar if you don't have that orange tip visible.